Hello again, everyone. It's Rob Ryder. It's the 8th day of October in the year of our Lord 2012. I'm going to do a video on contracts / security instruments, commonly known as a mortgage, deed of trust, security deed. I asked the question, if the Vatican is responsible for the UCC, why are you going to a private court for something governed by canon law? Doesn't make any sense to me. I suggest you look at Code of Canon Law 1983, not some canon law that some guy's making daily. The ones that the church has that are from the universal church, and they do have jurisdiction over the UCC, and it's governed by canon law. But canon law is only practiced in the diocese, not in those private courts you walk in. Those courts have separation of church and state. And then from last time, look at an acknowledgement of a warranty deed is of no value if the deed of trust, mortgage, security deed has not been lawfully addressed. I've said this I don't know how many times, and people still email me asking me about frickin' acknowledging the warranty deed. If you acknowledge a warranty deed, there's absolutely nothing wrong with it. It's lawful. You could do it. However, you put the property up as collateral on a deed of trust, and that's what they're going after. That's what has the securities on it. It's got two kinds of property, real property and personal property. Real property is the real estate, the personal property is the payments. All right, so you put the house that's on the deed of trust, or on the warranty deed, right, that you've got between you and the seller, you put that as collateral on a deed of trust between you and the lender. Or so they want you to think. So I'm just saying that you're going down there and doing the acknowledging the warranty deed without addressing the deed of trust, mortgage or security deed, whatever it's called, isn't going to do any good. So, get over it. Let's move on. How about we go ask them some questions and send them letters? So I have some ideas on it, and we're going to look at definition of contracts, and let's see where we go from there. So, again, I don't have any property, so I can't do this. But if I did, I would write something like this. It would be to the officers and directors of whatever the bank and the address is, right? However you guys want to do your headings, I don't really care. Officers, your corporation is a lender described in definition D of a security instrument titled mortgage upon which somebody is the borrower described in definition B. The mortgage has been sealed, delivered, recorded by the borrower in book, page, and office, wherever it's been recorded at, and as of today has not been acknowledged by the lender. You therefore have 15 days to execute and record your acknowledgement of said mortgage, or you are in breach of contract and transgressing God's law. As this instrument is already public record, foolproof evidence, I have only included a few selected pages for your enlightenment. So let's just really quick look at a standard mortgage, right? This could say deed of trust, it could say security deed. This one says mortgage. They're all the same. So in the upper right hand corner is where you get the information, where it's been recorded. This is book, looks like 19816, page 023. It's recorded in Palm Beach County, Florida, with Sharon R. Block, clerk and comptroller. As much of that shit as you want to write on the other page, put it on there. Okay? But here's where I was talking about the borrower was B, right? This isn't actually me, it's somebody else. So, all right. So who are we looking for? The lender is going to be definition D, and the borrower is going to be definition B. All right, so very first page, definitions. B is the borrower, D is the lender. All right. The lender is the beneficiary on a deed of trust, and a deed of trust is a deed. You've acknowledged it. They have not. Therefore, it's not a lawfully executed contract. Not binding on anybody yet until they sign it. Don't have anything to do with mirrors. It has to do with the lender. All right. Now, if your lender's not in business anymore, then you need to find out who took over their shit and send it to them in the name of these people, I guess. I don't know. Send them a copy of this. Say, here's the mortgage that I'm the borrower on. You've taken over for the lender, and D, but you haven't acknowledged the deed of trust. And how do we know it's a security instrument? Well, look it. They want you to think this is the lien. These are security instruments. This is the signature page. By signing below, a borrower accepts and agrees to the terms and conditions contained in pages 1 through 12 of this security instrument, and any writers executed by the borrower and recorded with it. This is a security instrument. It is not the lien. Very fucking important to understand. Sorry, Lord. I said I wouldn't swear in this one. Slow down. Okay. As the mortgage is a security instrument, I also ask for a certified copy of the lawfully recorded lien that this mortgage is a security instrument for, to be mailed along with a certified copy of your recorded acknowledgement of the mortgage to my mailing address provided below. If a lien is not recorded, delivered, nor noticed, then it is a statutory lien. Statutory liens have been ruled unconstitutional by the U.S. Supreme Court in King v. Mullins, being 171 U.S. 404. Without a lawfully recorded lien, the security instrument is a false obligation, a breach of good faith, and a sin to compel my performance. If copies of the recorded lien and your acknowledgement of the mortgage are not delivered within 15 days, then as grantor of the mortgage, I revoke it and demand that my securities and or their conversion and gain be returned to me immediately. This includes the title to the real property as well as the value of the personal property. This deed of trust got two kinds of property on it. I don't know which way is faster. All right, where are we going here? Okay, here's the real property. See attachment A. All right, gives an address. That's the real property. You just transfer the rights to it. Okay, so it doesn't matter if you've acknowledged the warranty or the warranty deed for the real property. You put it down as collateral, along with, a note, payments, yada, yada, yada. Those are all securities because they're on this security instrument. And all the security instrument does is convey interest in property. It doesn't give it to them. It just conveys an interest in it, but not all the interest. So, and it only exists lawfully until the lien or mortgage or first lien or whatever the underlying debt is satisfied. When it's been satisfied, the securities return to the mortgagor. That's you. I've done all sorts of videos on this stuff. Go watch the ones I did on mortgages. Anything that says mortgage, go watch a damn thing. Okay, and as far as this 15 days, I'm taking that from in Michigan. They have a process to get where there's a dispute over property, and an executory device is one of the things that could be causing the dispute. And an executory device is a device that's waiting to be executed. When I acknowledge a deed of trust and have it recorded, as the grantor, I've done all I can. I've recorded it with the Register of Deeds. I can't change my mind now. It's been recorded. However, for it to be binding in law, because it is a deed, and we've had numerous counter trolls tell us, well, a deed is a deed is a deed. Deeds are used in common law. If it's a deed, for it to be lawfully executed, the lender, beneficiary, has to acknowledge it. They haven't done that yet. And they know it. They can only acknowledge it after you die. If necessary to compel you to conduct your business in good faith, I will petition the bishop of the diocese as judge of first instance for his assistance in gaining the return of my property and to inquire into the business practice of your corporation. He having exclusive jurisdiction over faith, sin, law of contracts, oaths, instruments under notary seal, and the like. I am sure you're aware that the Universal Church and its courts have jurisdiction over the entire world. I come to you first to settle the matter and ask that you let your conscience be your guide. Adhere to your oath and operate in good faith. Failure to do so could be construed as heresy and eternal damnation for your soul. Fear God. Mail your acknowledgement of the mortgage and certified copy of the recorded lien, or the title to the real property and the conversion and gain of the personal property to whatever your mailing address is. In closing, your ability in this manner to operate in the unconscious world is terminated. You are personally responsible and bound by oath for the actions of your corporation you represent. And testimony whereof I have hereunto set my hand and fixed my seal this 8th day of October in the year of our Lord 2012. Okay, and how do you know it's your seal? Well, because it says seal behind it. You put your signature at your seal, and then you have a notary witness it. And you're going to see this on every, what's it say here? Borrower seal. It's because in common law and deeds, everything must be sealed. It doesn't need to be signed. But a man can choose his seal to be whatever he determines it to be. So by them putting seal behind here and you writing your name, you said that's your seal. Common law. Lawfully. Everything is done by deed. It's used for all conveyances and contracts. When you see the word seal, and then you went before a notary, and then it was recorded with the Register of Deeds, or whoever they call these people in this state, right? It's a lawful document. As far as the grantor, you have lawfully conveyed the property if the beneficiary acknowledges it. And until he does, and once you tell him, hey, you haven't done it yet, you got 15 days or you're in breach of contract, then you can revoke it. You know, I did a video a long time ago about revoking a deed of trust. It's all true, right? All that stuff is true. It can be done. Things have to be done in a particular manner, or, you know, you got to start at one. You can't start in the middle. Acknowledging a deed, warranty deed, is in the middle, right? It's not the place to start. It was good to do that and find out, hey, they will do it. Hey, we've learned some stuff by asking them questions. That was all good, right? And it's lawful to do, but it's not the right place to start because you put it up as collateral on this damn piece of paper. This is what they're going after. Okay, so newadvent.org contract. This newadvent.org is a wonderful site, right? It has all sorts of hyperlinks to other places, wherever they're getting the information from the scriptures or whatever. You know, they tell you and they link you to it. It's wonderful. So the Canonical Immoralist Doctrine. The Canonical Immoralist Doctrine of this subject is a development of that contained in the Roman civil law. In Roman law, a mere agreement between two parties to give, do, or refrain from doing something was a nude pact, a pactum nudum, which gave rise to no civil obligation and no action laid to enforce it. If it was between two private individuals, the court had nothing to do with it. That's a strange law. I don't seem to be how it happens, but that seems to be what they're saying. So this nudum pactum, this is off of some other site. I wanted to get a definition of it. Literally means bare or naked promise. In common law, it refers to a promise that is not legally enforceable for want of consideration. An example of this pact would be an offer to sell something without corresponding offer value in exchange, right? So we got to have, whatever that, consideration, that stuff. While the offer may bind a person morally, since the offer has not been created with any consideration, it is gratuitous and treated as a unilateral contract. The offer is therefore revocable at any time by the offerer before acceptance by the offeree. The offer is therefore revocable at any time by the offerer before acceptance by the offeree. They're talking about you. This is a private contract between two individuals. It needed to be clothed in some investal contract investive fact which the law recognizes in order to give rise to a civil obligation which should be enforced at law. Not that the nude pact was considered to be destitute of all binding force. It was given to natural obligation, and it might afford ground for legal exception. A man of honor would keep his engagement even if he knew that the law could not be invoked to compel him to do so. So they have these courts called the Court of Conscience. And if you go look up the definition, it says they're minor courts in trading cities for disputes of little value, something like that. That's going to be the legal exception. They're going to get you for a conscious thing is what they're going to try to get you for. A religious corporation is going to try to use basically canon law against you, but they don't have any jurisdiction because they're not an ecclesiastic court. It doesn't mean they're not going to try. Moral theology, being the science of Christian conduct, could not be satisfied with a mere legal view of the effect of an agreement. If the agreement had all other requisites of a valid contract, moral theology must necessarily consider it to be binding, even though it was a nude pact and could not be enforced in the courts of law. If an agreement had all the requisites of a valid contract, so if it has the stuff for a valid contract, it is a contract. If it doesn't, it isn't. Canon law made this moral attitude its own. In the Decretals of Gregory IX, it is expressly laid down that pacts, however nude, must be kept, and that a strenuous endeavor must be made to put into execution what one has promised. It thus came to pass that nude pacts could be enforced in the Christian courts, and the church legislation served eventually to break down the rigid formalization of Roman law and prepare the way for a more equitable law of contract, which all Christian nations now possess. I believe that would be the Uniform Commercial Code. And it can be heard in the Christian courts, which aren't the private courts you're walking into. These are wherever the bishop is. It's called a diocese. You may want to look it up. In the canonical and moral doctrine, there are hardly room for the distinction between nude pact or mere agreement and a contract. The Roman jurist definition of the former, the nude pact, is frequently used by canonists to define a contract. They say that a contract is consent of two or more persons to the same proposal, or, bring it out a little more definitely, the effect and object of a contract. They define it to be an agreement by which two or more persons mutually bind themselves to give or do or abstain from something. Well, you're the only one that signed the damn thing, right? The bank hasn't signed it. The bank ain't signed it. So guess what? There's not the consent. It's not an agreement of which two or more persons mutually bind themselves. And so you give them 15 days to do it. Well, they can't do it. They're not going to do it. That would be unlawful. For the moralist point of view, then, every agreement seriously entered into by those who are capable of contracting with reference to some lawful object is a contract, whether such an agreement can be enforced in the civil courts or not. We'll take it to we can't enforce it in the civil courts, but they can in the ecclesiastic courts. The intentions of the parties is looked at, and if they seriously intend to bind themselves, they are contractually relations between them. There is a contractual relation between them. This doctrine, however, gives rise to the question of some importance. The Church fully admits and defends the right of the state to make laws for temporal well-being of its citizens. All states require certain formalities for validity of certain actions. Last wills and testaments are familiar examples, and although they are not strictly contracts, yet the principle is the same, and they will serve for an example of what is meant. A deed is the only formal contract of English law. And so, certain formalities, there's only one kind of formal contract in English law, and it's a deed. And deeds are used for conveyances and contracts, and it doesn't matter what the damn title is. If you're sealing it, it's a deed. A deed, the only formal contract in English law, of English law. Did I say that already? I may have. is another example. A will, as in by your will, destitute of the requisite formalities, is null and void at law. But what is the effect of such voiding law in the form of conscience? This question has been much debated among moralists. Some have maintained that much of the law is binding in the internal as well as external form. So the church got two forms. Internal is, what happens within the church. External is what happens between the church and the civil society, because the church, the Roman Empire, right? When the Roman Empire finally disintegrated about the 6th century, the Roman bishop and the Catholic Church became a sovereign nation on its own. It's the oldest sovereign nation on the face of the earth. So their first line, first time. They have all the original contracts. So that the form of contract destitute of formalities required by law is null and void. Okay, so if it isn't done properly, it's null and void in law. The common opinion takes the middle course. It holds that the want of formality, though it makes the contract void in the eyes of the law, renders it only voidable in the form of conscience, which is the ecclesiastic court, so that until one of the parties moves to set the contract aside, it remains valid, and anyone deriving benefit under it may enjoy his benefit in peace. So you need to go tell them, you have not acknowledged the deed of trust, acknowledge it now, return my property, yada, yada, yada. Well, now you've been noticed, right? You've moved to set the contract aside. If, however, the party interested, you, moves to set it aside by sending the damn letter and does so effectively by having recourse to a court of law, if necessary, which would be the ecclesiastic courts, both must then abide by the law which makes the contract void and of no effect. Okay, and here's the essentials of a contract, right? Consent of the parties. Okay, we already know that. So that each may know that the other party consents. They both have to sign the damn thing. It has to be manifested. Manifested. Right? They have to sign the paperwork, or it's not a binding contract. All that is required by nature of contracts is there should be a mutually manifested agreement of the two wills. By your will, you've decided to do it, and by their will, so did they. There will be such agreement when one party makes an offer to the other, and this one manifests his acceptance of the offer by posting a letter or sending a telegram. Right? They haven't told you they've accepted it. There is then consent of the two wills to the proposal. And so there is a contract. Jeepers. Such mistakes, mutual consent to the same proposal may be hindered by a mistake of one of the parties. Such a mistake are not infrequently caused by the fraud or misrepresentations of the other party. Go figure. They're telling you. The mistake is they didn't sign it. If, however, such a mistake has been caused by fraud or misrepresentation of the other party to the contract, and the party deceived would not otherwise have entered into it, it is only fair that the deceived party should be able to protect himself from injury by retiring from the agreement. The consent of the parties must be deliberate and free, for perfect and grave obligation cannot arise from consent which is not deliberate or free. Hence we must see what the influence of fear upon validity. Hence, we must see what the influence of fear is upon the validity of a contract. If fear goes to the length of depriving one of the parties of use of reason, he cannot, within the state, give a valid consent, and the contract is null and void. That's for anybody who's ever gone to court, to jail. Right? But we're not concentrating on that part. We're just concentrating on deeds of trust. Fear, however, does not really produce such extreme effects. It leads a man to his natural use of reason, capable of consenting without his consent, or withholding his consent. Even grave fear then does not itself invalidate a contract, but it is unjustly caused by the other party to the contract with a view of forcing him who is under the influence of the contract. The injured party may withdraw from the contract. Some contracts, such as marriage, thus entered into under the influence of grave fear and justly caused by the other party, the contract with intention of compelling consent, are made invalid by canon law. Some authorities have even held that all such contracts are invalid by natural law, but the opinion is at most only probable. There's something about getting married, right? But yeah, on that later. But marriage is basically a contract. A person must have the use of reason in order to give a valid consent to a contract, and his contractual capacity must not have been taken away by law. Those who have not yet attained the use of reason, imbeciles, and others who are perfectly drunk so that they do not know what they are doing, are incapable of contracting by the law of nature. Okay, some more things like that. A contract cannot be bound. A contract cannot be a bond of iniquity, and so an agreement to commit sin is null and void. The opinion seems to be at any rate probable. If a contract is not sinful in itself, but voided by positive law because the bank hasn't signed it, it will be valid until it is set aside by the party interested. You got interest in having in that deed of trust. It doesn't matter if you're being foreclosed on, if you've lost the property, or if you just have a mortgage. Anybody who has a deed of trust, if you are on a deed of trust as the borrower and the bank hasn't acknowledged it yet, send the damn letter and get your property back. When persons enter into a contract, each party promises, promissory oaths, to give, do, forbear something in favor of the other. The benefit of thus, which thus immediately arises from the contract, and which is the cause of it, is called the consideration. The benefit which thus immediately arises from the contract, and which is the cause of it, is called the consideration. Well, what caused it? The promise did. The promise is the consideration. It is a necessary element in a contract, and if it is wanting, the contract is null on account of failure of necessary condition in the agreement. The courts of civil law will not enforce civil contract unless there has been valuable consideration in it. Now that's civil law. Unless there's been valuable consideration. Well, they make sure there's valuable consideration, but that's only one kind of consideration. Mere motives of affection or moral duty will not suffice. That's called good consideration. Good consideration is by affection, by blood or affection. The rule, however, only affects legal obligations. It has nothing to do with obligations in conscience. A valid contract imposes on the contracting parties an obligation of justice. These courts have a guy called the promoter of justice, to act conscientiously according to the terms of the agreement. They will be bound to perform not only what they expressly agreed to do, but whatever the law or custom or usage prescribes in the circumstance. Well, there's a thing called the UCC. What's the law say? The obligation arising from a contract will cease when the contract has been executed, when a new one has been substituted for the old one, by the free consent of the parties, when the party mutually and freely withdraw from the contract. When one of the parties fails in what he has promised, the other will, as a rule, be free. Okay, so if they won't sign it, you are free. A contract may be concluded not absolutely but conditionally upon happening. Okay, that isn't so important. You got conditions precedent and condition subsequent. In civil law, contracts is defined as union of several persons in a coincident expression by will, by which their legal relations are determined. Right? So by your will, this coincident expression consists of an agreement and promises enforceable in law, and on the face of the matter capable of having legal effects, an act in the law, yada yada yada, the duties and rights which can be dealt with by a court of justice. So when both of you sign it, then it consists of an agreement and promises enforceable by law when you both seal it. Until then, it's not enforceable by law. Thus, while every contract is an agreement, not every agreement is a contract. Right now, this is not a contract, it's just an agreement. A mutual consent of two persons to walk out together or to dine together would be an agreement, and yet not what in jurisprudence is known as a contract. For such consent contemplates the producing of no legal right or of any duty which is a legal obligation. Subsequently, only these or similar explanations can be properly adapted to the time-honored definition of a contract as understood in English law, a definition commended by Chancellor Kent for its neatness and precision, namely, an agreement of two or more persons upon sufficient consideration to do or not to do a particular thing. Definition consideration is an essential element for the formation of a contract. It may consist of a promise to perform a desired act or a promise to refrain from doing an act that one is legally entitled to. In a bilateral contract, an agreement by which both parties exchange mutual promises, each promise is considered as sufficient consideration for the other. Doesn't need to be valuable consideration. Two people signing makes it a contract. That's the consideration. The promise is. In a unilateral contract, an agreement by which one party makes a promise in exchange for another's performance, okay, you promise to pay these things if they give you a loan. The performance is consideration. The performance is consideration for the promise, while the promise is consideration for the performance. So you gave your consideration, right? But they, they want to say they lent you some money. What have they done? Right? They haven't done anything. Nada. Consideration must have a value that can be objectively determined. A promise, for example, to make a gift or a promise of love or affection is not enforceable because of the substantive nature of the promise. Grant and convey. That's by love and affection. A grant's a gift. When you read these things, they say you're granting your property to them. So it's not enforceable. Right? They're telling you it's not enforceable for you to grant it to them. That can't be enforced. Traditionally, courts have distinguished between unilateral and bilateral contracts by determining whether one or both parties provided consideration, and at what point they provided the consideration. Bilateral contracts were said to bind both the parties the minute the parties exchanged promises, as each promise has been deemed sufficient. That hasn't happened yet. Unilateral contracts were said to bind only the promisor and did not bind the promisee unless the promisee accepted by performance the obligation specified by the promisor's offer. Until the promisee performed, he or she had provided no consideration under law, so it's not a contract. The promisee is the mortgagee, the beneficiary, the lender. And kinds of contract. Roman civil law defined contracts as real, verbal, literal, consensual. A real contract was one such as a loan or pledge, which was not perfected until something had passed from one of the parties to the other. A verbal contract or stipulation was perfected by a spoken formula. This formula consists of questions by one of the parties and exactly corresponding answers by the other. Do you agree or promise to give me 5 pieces of gold? I agree or I promise. The similarity may be noted of this to the modern form of administering an affidavit or for taking acknowledgments of a written legal instrument. A literal contract was perfected by a written acknowledgment of a debt and was used chiefly in the instance for a loan of money. So I think that was perfected by a written acknowledgment of the debt. Consensual contracts were those which sale would be an example, which might be perfected by consent, and to which no particular form was essential. In English law, the principal division of contracts is that those by writing under seal and those known as simple contracts. There are also contracts by matter of record, such as recognizance or judgment by confession, contracts in court, which need no further description. Simple contracts include all contracts written but not under seal or of record, and all verbal contracts. So if it's not under seal, it's a simple contract. Now this thing here, there are also contracts by matter of record, such as recognizance or judgment by confession, which is what they're trying to get you to confess when they take you to court. What do they ask you? Guilty or not guilty? Right? They're trying to get you to confess. And then there's contracts in court. Everything's a contract. Contracts are governed by the UCC. UCC is governed by the Vatican. Vatican's governed by canon law. You're taking it to the wrong court if you're not going to an ecclesiastic court. Okay, requisites of a contract. According to Roman law, such a contract as that of sale required namely a good legal reason. Okay, so a contract as that of sale, right? That's what your warranty deed is between you and the grantor, the guy you're buying the property from. It's a sales contract. By the law, informal contracts which had no just cause that were ineffectual. Stipulations, irregular in form, were termed mere agreements to which the ancient law attached no obligation. Stipulations, irregular in form, were termed something, mere agreements, to which the ancient law attached no obligation. So I think it's talking about all the extra garbage you want to add on to your... Again, we're talking about the real property deed now. This is the warranty deed, grant deed, whatever they call it, not the deed of trust. Right? Deed of trust is a security instrument. The warranty deed is a sales contract. Roman jurisprudence let some engagements rest on the mere integrity of the parties who contracted them, thinking it more conducive to the cultivation of virtue to leave some things to the good faith and probability of mankind than to subject everything to the compulsory authority of the law. Yeah, right. That's why there's courts are so busy, right? Because good faith. I don't think so. As the civil law jurist admitted the moral obligation of good faith and probity, so an eminent English judge concedes that by the law of nature, every man ought to fulfill his engagements. But it is equally true, he continues, that the law of this country supplies no means nor affords any remedy to compel the performance of any agreement made without sufficient consideration. That the law of this country supplies no means nor affords any remedy to compel the performance of an agreement made without sufficient consideration. They're saying their courts can't compel it because the other side hasn't signed it. So they can't compel them to do anything. There hasn't been sufficient consideration. Such an agreement, he adds, a mere agreement giving rise to no action at law, the learned judge conceding that understand the maxim may, as it clearly does, differ from the sense in the Roman law. A moral consideration has been said to be nothing in law. The moral obligation of a contract is of an imperfect kind, to quote an eminent American jurist, addressed to the conscience of the parties under the solemn admonitions of the accountability to the Supreme Being, but not to an earthly court of justice. With these doctrines of Roman and English law, we may compare the Scottish law, according to which no consideration is essential to a legal obligation. Okay, so no consideration is essential to a legal obligation. An obligation undertaken deliberately through gratuitously being binding. Though gratuitously being binding, it's only by gratitude. This, adds Mackenzie, is in the conformity with the canon law by which every word of a faithful man is equivalent to a debt. In the Roman law, fulfillment of illegal solemnities of a verbal contract was deemed to indicate such intention of contracting a valid and effectual obligation as to dispense with proof of any just cause. In the English law, it is not any verbal formality, but the solemnity of the writing and sealing which dispenses with proof of the valuable consideration in modern English law analogous to the old Roman just cause. And as a general proposition, essential to the validity of simple contracts, although in exceptional instances of negotiating paper always presumed and in favor of certain holders conclusively. That's a lot of crap being said there. The important thing there is, but the solemnity of writing and sealing which dispenses with proof of the valuable consideration. If it's been written and sealed, you don't have to have proof of valuable consideration. The consideration was the writing and sealing. That just made it lawful. This consideration is described generally as the matter accepted and agreed upon as an equivalent for which a promise is made, and one promise would be legal consideration for another. But the English law infers that a man chooses to bargain for or to be of some value to him, and therefore does not allow the adequacy of the consideration to be inquired into. Okay, so what's the value of the consideration? What's the value of their promise to you right now? Well, first of all, they haven't given it to you. All right, so it has no value. The consideration must, however, be of some value in contemplation of law. A promise, for instance, to abstain from doing what the promisor has no right to do is a promise of no value and therefore no consideration for a contract. However, a promise is consideration for a contract, just not when it's a promise not to do something they can't do anyways. No obligation can, by English law, result from an agreement, a moral in a legal sense. By this is meant not only that it is morally wrong, but that according to the common understanding of reasonable men, it would be a scandal for a court of justice to treat it as lawful or indifferent, though it may not come within the positive prohibition of a penalty, or penalty. It may not come within any positive prohibition or penalty. In other words, we're working in the gray, and that would be a scandal, because the court would be indifferent, right? The court works in black and white. Either the law is on your side or it's on the other guy's side. And since equity follows the law, you want the law to be on your side. Some civil law authority, instances of promise by an... I don't really care about that. But there is no wanting instances of contracts opposed to the policy of law which yet conflict with no moral law. Yeah, again, it's all the gray, right? If they don't sign it, you don't say nothing, then there really never was any contract. They don't have to do a damn thing until you tell them, hey, you haven't signed the contract yet. If you don't sign it in 15 days, you're in breach of contract. And then I void the frickin' deed of trust. A contract induced by what in law is deemed to be fraud may be rescinded at the election of the party defrauded. Well, bingo. But the general fraudulent conduct or general dishonesty of purpose, which is all deeds of trust, or the mere intention or design to deceive, is not sufficient unless the evil acts and qualities have been connected with a particular transaction. Them just thinking about doing it isn't enough. They have to have done it. They're doing it right now. They haven't acknowledged the deed of trust. There is no contract. In the instance of a sale, the seller was, by the Roman civil law, held to an implied warranty that the thing sold was free from such defects as made it unfit for the use for which it was intended. What's a sale? A contract between two parties called respectively the seller, vendor, and the buyer, purchaser, by which the former, in consideration of payment of promise of payment for a certain price in money, transfers to the later the title and possession of the property. That's what the dude gave you with a warranty deed. He gave you title and possession to the property, to the land. Transfer of property for consideration either in money or its equivalent. That's a warranty deed equals a sales contract. By the English law, there is, if the thing be sold for a fair price, and be at the time of the sale in the possession of the seller, an implied warranty of title, but of a quality there is no implied warranty. but of quality there is no implied warranty, except as for food or domestic use. An implied warranty of title. But we don't know what quality the title is. The writers of the moral law, observing Chancellor Kent, hold it to be the duty of the seller to disclose the defects which are within his knowledge. But the common law is not quite so strict. If the defects in the article sold be open equally to the observation of both parties, the law does not require the vendor to aid in assisting the observation of the vendee. Well, the problem is they haven't recorded the lien. So it's hidden, right? You can't see it. So they do have an obligation. And that would be the title insurance company, who's supposed to insure the title to make sure it's good. Well, if there's no lien recorded, then there's no reason to have title insurance. There's no reason for them to hold the title anymore. The title company, they need to return your title. Respecting what may be termed generally motives and inducements of a contract, the same authority cites, in accordance with the doctrine of English law, that although misrepresentation or fraud will invalidate the contract for sale, the mere concealment of material knowledge which the one party has touching the thing sold, and which the other does not possess, may affect the conscience, but will not destroy the contract. For that would unduly restrict freedom of commerce, and parties must at their own risk inform themselves of the commodities they deal in. In a note, Cheerio is referred to as a favoring the view of the conscience forbids the concealment, the commenter adding, "It is singular, however, that some of the best ethical writers under the Christian disposition should complain of the moral lessons of Cicero as being too austere in their texture, and too sublime in speculation of the actual use. As fraud, so coercion, termed in English law duress, or the threat of it, constitutes valid defense for fulfillment of the contract." As fraud, so coercion, termed in English law duress, and the threat of it constitutes a valid defense to fulfillment of a contract. Threat, coercion, and duress are valid defenses to fulfilling that piece of paper that you sign on the side of the road. A certain French ordinance has been thought to have perhaps suggested the English statute of 1689, which recites its purposes to be prevention of many fraudulent practices which are commonly endeavored to be upheld by perjury and subordination of perjury. This is what they try to get you to do when you go to court. They want you to plead guilty to perjury. Right? IRS case, they're going to charge you for a false claim. Well, a falsehood means you lied. That's perjury. According to the statute, it requires that certain contracts be in writing, and those for sales of goods, wares, or merchandise over £10 price in writing, or there be a part delivery or a part payment. This enactment, known as statute of frauds, has with numerous variations been embodied in the statutes of the United States. Carrying a quote from the American commenter, "It's influenced through the whole body of our civil jurisprudence." Yeah, they're using this thing all the time. According to the statute, it requires that certain contracts be in writing, and those for sales of goods, wares, over £10 in price in writing, or that there be part delivery or part payment. By the early Roman law, many contracts were enforceable by legal action after any lapse of time, however long. But to quote the Institutes of something or other, so that certain prescribed periods, no legal remedy would be provided for force obligations of the contract. This is, we're talking about statute of limitations. But modern statutes, as well in England as throughout the United States, limit the remedy to certain periods for the time by entering into contracts adopting the manner of the Roman constitutions. The legal maxim, the law aid the vigilant, not the careless, is applicable to private suitors. But no time runs against the king, and therefore, unless specifically mentioned, the government is not induced within the restrictions of the statute of limitations. The government is not included within the restrictions of the statute of limitations. Well, you're of the Society of Universal Church of Jesus Christ, then you got the Vatican to protect you. They're the government. According to ancient legal conceptions, these statutes ought not to bind the king, for the reason he is always busy with the public good and therefore has not the leisure to assert his right within the times limited to subjects. Right? We don't want to be a subject anymore. To secure inviolability of contracts, the Constitution of the United States provides that no state shall pass a law impairing obligations of contracts. By obligation, it is meant that legal obligation which exists wherever the municipal law recognizes an absolute duty to perform a contract. And the word contract being used in this clause of the Constitution without qualification, the protection of the Constitution is not confined to executory contracts, but embraces also executed contracts as well as grant, which, because it amounts to an extinguishment of a right of the party, implies a contract not to reassert the right. And the Constitution also protects even state charters granted to private persons for private purposes where there is a literary, charitable, religious, or commercial. Whether these be literary, charitable, religious, or commercial. Okay. This stuff here has a lot to do with our birth documents, right? Because we gave them a grant and convey, somehow when we were a child, and we haven't gone to, because it's a grant, we can stop it at any time, right? It's not something for them to sign. It was a unilateral contract. So, but I don't want to talk about that stuff because it gets too confusing. The main thing is, here's some more stuff. I'll just have this on here to read. Back to this. Right? And this. This is a security instrument. If it says mortgage, deed of trust, security deed, whatever, right? It's a security instrument. It's not a lien. A security instrument can only exist if there's an underlying lien. When the lien has been satisfied, the real mortgage, then the securities are supposed to be returned to the mortgagor. That would be you. Right? So if they can't produce the lien that this security instrument is attached to, if it's not been recorded, then it's a statutory lien. And statutory liens are unconstitutional. And these are all things I've covered on previous videos. So, it's really nothing new. It's just, the thing is, where are you going to find justice? It's easy to point out the defects in due process. The hard part's been finding justice. So the latest attempts have been, let's go see what happens at the diocese. But to do it lawfully, you first have to go to your brother first, right? And so you give them 15 days to sign the contract. If they don't sign the contract, then you're going to revoke it. And you're going to demand your securities, right? If they don't send them to you, then you're going to go petition the bishop, judge of first instance. And this will be your evidence that you went to them first. Because you're going to go here and you're going to get this under a notary seal. They just need to witness your signature. Anything under a notary seal just gave the ecclesiastic court's jurisdiction. Because now it's a matter of faith. There's a witness saw that you did this. If the bank doesn't comply, they've got a problem because they've taken oaths. 12 USC subsection 72 or 73 is on oaths. And it says that they've taken an oath to operate in good faith. And they're not. So, because they haven't signed the contract, it's binding until we do an action to say, hey, either acknowledge the contract or you're going to revoke it. And that's what this letter is for. This is just to give you your evidence in case you need to go to the others to the diocese. And I'm just kind of hoping, by the way it's written, that that's where we're going to take it to, that these guys get a wake-up call, because when the Inquisition comes, you had better fear God, because they're going to ask you. So, all right, I'm going to leave it there. You all have a great night, and I hope it was of use. And if you're going to write one, please do it soon. Whether you are in foreclosure, not in foreclosure, already lost your property, doesn't matter. If you're the borrower on a deed of trust and it's recorded somewhere and it has not been acknowledged by the lender, write them the damn letter. Until you die, they can't sign it. As long as you're alive, right, they can't sign it, so they're going to have to give you back your securities. And they don't want to, well, we're going to take them to the Vicar General. The vicar will get to him. He's the executor. He executes the judgments of the judge of first instance. And the judge is going to find on your side. It's my opinion. See what happens. See ya.